Welcome everyone to our Berkeley Law alumni event. My name is Yuri Kapkian. I'm class of 2001, and I head up the Los Angeles chapter of the Berkeley Law Alumni Association. I would encourage all of you to attend some of our upcoming events that we have planned. You'll see a link in the chat to a list of those events. You might be interested to know that for today's talk, we have hundreds of alumni registered from many different class years, starting from the class of 1952 all the way through the class of 2020. So thank you all for being here. In terms of logistics for today's talk, please place any questions you have in the chat during the talk, and we'll get to those afterwards. So today, we have a special presentation, a timely presentation from Assistant Professor Jonathan Gould. His talk is titled "The Broken Branch, the Role of Congress in a Partisan Age." Professor Gould's research focuses on the relationship between politics and law, with special attention to Congress and the legislative process. His scholarship has been published in various law review journals, such as the Yale Law Journal, the Virginia Law Review, the Georgetown Law Journal, and the Vanderbilt Law Review. His recent article, Law Within Congress, won the Association of American Law Schools 2020 Scholarly Papers Prize for work by a faculty member in their first 5 years of law teaching. Professor Gould received his JD, magna cum laude, from Harvard Law School, where he served as president of the Harvard Law Review, and his PhD from Harvard's Department of Government. And he's told me that he's very happy to finally be able to enjoy the sunshine on the West Coast. He's worked as a law clerk for the Honorable David Barron on the U.S. Court of Appeals for the First Circuit, at the U.S. Department of Justice's Civil Rights Division, and at the Public Citizen Litigation Group. So with that, let me turn it over to you, Professor Gould.
Thank you so much, Yuri, and thank you to the Berkeley Law Alumni Affairs Office. It's really terrific to be here and to be here with all of you. I was only in Berkeley for a few months when COVID hit, but I feel even online, I've been getting to know not only students and colleagues, but also members of the alumni community. And I'm really, really thrilled to be here with all of you today. Let me share my screen and then we can jump in, and I'll speak for about 30 minutes and then we will open it up, and I'm really looking forward to the discussion. Fantastic. So my topic today is the broken branch, and I intentionally put a question mark because part of what we'll be speaking about is Congress broken, and what does it mean for Congress to be broken? And if so, how do we fix it? And in particular, how do we think about Congress in a partisan age? By way of introduction, Yuri gave my basic bio, but one of the courses I teach here at Berkeley is legislation and statutory interpretation. And in that class, the first third of the class focuses on how Congress works, what legislative procedure looks like, some of the themes we'll be talking about today. And then the back half of the class talks about statutory interpretation and the relationship between Congress's internal functioning and what's thought of as kind of more typical lawyerly work and lawyerly questions. So this talk is closely related both to my research, but also to my teaching and to conversations I've had with Berkeley Law students during the year and a half that I've been here. So by way of agenda, we're going to start with a quick overview of what is the legislative prognosis for the new Congress. We're just over a month into a new Congress. We're going to look at what has been done, what likely will be done in the months ahead. So that's going to be very timely, very practical. Then number two, we're going to take a step back and ask a much more theoretical set of questions. What does it mean for Congress to be broken? The term is thrown around a lot, but often without a lot of specificity. So what are the various kind of conceptions of Congress working well or poorly, and how do we think about that? Number three, we're going to do a case study around the filibuster and reconciliation. And this is obviously one of the hottest topics nowadays. Will the Democrats kill the filibuster? If the filibuster persists, what parts of the Democratic agenda can get through in spite of the filibuster? And we'll dig deep on that as a case study of how congressional rules shape legislative outcomes. And then finally, we're going to end by talking about possibilities for reform. How might Congress work differently, and what are the various institutional levers that reformers might pull on? I've already gotten a couple questions submitted in advance, which are excellent. And if there are more questions, feel free to drop them in the Q&A, and I'll be excited to talk about them at the end. Great, so short-term priorities for the new Congress. I think in the very short term, I see two. The first is the COVID relief package. So as most of you probably know, President Biden proposed a $1.9 trillion COVID relief package. It included a lot of aid for state, local, and tribal governments. It included funds to aid in the vaccine rollout. And then it included a number of other things kind of other than direct funds. So it included a federal eviction moratorium. It included extending the SNAP, the Supplemental Nutrition Assistance or food stamps program. And then expansions in healthcare. It's tough to understate just how monumental the proposed COVID relief package is that came out of the Biden administration. Of course, the president doesn't make the laws, Congress does. And while I think much of what President Biden proposed will become law, not all of it will. In terms of the timetable on this, the goal that both the administration and Democratic congressional leaders have is to have something on the president's desk by the middle of March, which is when some unemployment benefits are set to expire. So that's kind of the time frame that they're working on. A week ago today, the House Ways and Means Committee reported out its portion of the COVID relief bill. That portion notably includes the $1,400 stimulus checks for individual households, which has gotten a lot of public attention. It also includes an expansion of the child tax credit, as well as a number of the other proposals that President Biden put forth. The Ways and Means Committee will, of course, not have the last word. It's one of 12 House committees with a voice in this process. And then, of course, there's the Senate side of things, which I'll talk about more in a few minutes. So we are very far from the end of this process, but things are moving along, I think, as quickly as could be hoped for. The other really short-term priority is executive branch nominations. So there are 23 cabinet level officials. 7 of them have been confirmed, and we're about 30 days into the new administration, plus or minus a couple. Those 7 who've been confirmed are some of the most high profile. We have a Secretary of Defense, we have a Secretary of State. We notably do not yet have a Senate confirmed Attorney General, and there are a number of other cabinet positions where we don't yet have a Senate confirmed official in place. This is a slightly slower pace than what we saw in the Trump administration, but I think the more relevant comparison is this is a much slower pace than what we saw in the Obama and Bush and Clinton administrations. That those administrations, many of them had substantial numbers of cabinet members confirmed on day one, a majority of the cabinet confirmed within a week or two, and things here are much slower, which I think might partially be a reflection on the executive branch side. It took a little while for President Biden to name his full cabinet, but part of it is issues in the Senate, that things are not as collegial and not as efficient as they once were. So those are the short-term priorities, COVID and confirmations. We then have a number of additional longer-term priorities that we know less about. The one where we have the clearest sense is immigration reform. So on President Biden's first day in office, he put forward an immigration reform bill that would really mark a dramatic change from what we saw in the Trump administration, not only in tone, but also in substance. So the centerpiece of the policy change is a path to citizenship, is provisions that would allow undocumented immigrants to obtain legal status and setting out the avenues through which they could do that. But it would also provide funding to local governments and educational institutions to provide support for folks wanting to become citizens. It would re-implement programs around economic development in El Salvador, Guatemala, and Honduras in order to ensure better conditions there, which would perhaps have kind of downstream effects on our immigration system. And it makes a number of other changes to work authorization, to the visa programs, in order to be more, I would say, to be more immigration friendly. We do not know if this will happen. I think there are real reasons to be skeptical that this will ultimately become law, and I'm happy to talk more about why I'm skeptical on that. But I think it is really powerful as a signal, especially in the aftermath of the Trump administration, that immigration reform got a lot of attention, a lot of press, and President Biden chose to make it one of the things he talked about on day one, which there are many other issues that he has talked about since day one, but immigration was really a day one issue. I have less to say in detail on the other three issues on the slide: climate, democracy reform, and judicial confirmation. On climate, thus far, we have seen a number of executive orders used to implement the new administration's climate policy. The new administration is being extremely aggressive and proactive on addressing the threat of global climate change. They have not yet put forth a climate bill. I think part of the reason might be that a climate bill would face a very steep road ahead, because much of it would require 60 votes in the Senate, and I'll talk more about that 60 vote threshold. Likewise, democracy reform, we've heard a lot about any number of things: automatic voter registration, perhaps electoral college reform. DC and Puerto Rico statehood have gotten a lot of attention. So I expect there might be legislation on one of those lines in the months ahead, but we haven't seen it yet. One model for that might be a bill called H.R. 1, which is a bill that Democrats put forward a couple of times during the Trump administration, knowing it would not become law, but was kind of a comprehensive, the Democrats' comprehensive democracy reform agenda. And then finally, we have judicial confirmations. President Trump has now filled an unprecedented number of seats, or unprecedented in modern times number of seats in the federal judiciary, certainly for a one-term president. But there are still open seats. I expect a number of judges will be taking senior status in the months ahead. A few already have. I imagine there will probably be one Supreme Court vacancy at some point during President Biden's term. And when there is a judicial opening, that's going to become top priority. And even now, I know the administration is going through vetting of potential judges. Now I want to take a step back and ask, so that's kind of the here and now. Take a step back and ask, what does it mean for Congress to be broken? So the title of my talk comes in part from this great book that came out about a decade ago by Tom Mann and Norm Ornstein, who are two of the leading scholars of Congress. And they titled their book, The Broken Branch, the argument that Congress isn't working. I just want to delve a little bit deeper. What might it mean for Congress not to be working? Because I think that term gets thrown around and people might mean different things by it. In particular, I want to posit that we might have a substantive view of what it means for Congress not to be working. We might have a procedural view, and then we might have kind of a blended conception that has both substantive and procedural elements. So a substantive critique of Congress. This is pretty simple. This is the argument that Congress is failing to legislate in the national interest. Congress is failing to do what it should do. And there are both kind of general versions of this and more ideologically tinged versions. So the general version, which I would hope would be acceptable to both Democrats and Republicans, liberals and conservatives, is that Congress fails to do basic things that we all agree it should be doing. It often doesn't pass a budget. We've seen relatively frequent government shutdowns. We've seen issues around raising the debt ceiling. These are things Democrats and Republicans surely disagree about what should be in the federal budget, but you would hope that there could be some measure of consensus that passing a budget, even a kind of subpar one, is better than a government shutdown. So that's kind of the general version of the critique. The substantive critique also often comes in kind of a more ideological form. And this is especially true on the left. There are many on the left, and I'm sympathetic to this view, who say the problem with Congress is it's not doing the things it should be doing. So Congress should address the climate emergency. Congress should address the fact that there are millions and millions of undocumented people here falling through the cracks. Congress should, we can pick our issue, should enact a better education reform, should help more people get health care, kind of pick your favorite issue. There can be kind of an ideological version of that critique. Of course, the problem with those is whether I think Congress is broken or not turns on my politics. So it's a kind of very specific view. It's an appealing one in some respects, but it's not a kind of generally applicable one. So those are substantive accounts of how we might think about whether Congress is broken. We also have procedural critiques of Congress, where we say what makes Congress broken or not isn't their failure or success in passing a budget or a climate bill, but rather kind of institutional or structural things about the institution. So for example, excessive veto points is often talked about. So the US lawmaking process has more electorally generated veto points than any other lawmaking process in any other advanced democracy. So for a bill to become law, this kind of has a Civics 101 flavor. It certainly needs to pass the House, the Senate, and get signed by the president, but it also needs to get through committees in both the House and the Senate, which create their own hurdles. In the Senate, we will typically need to clear a filibuster. The president has veto power. Judicial review serves as a kind of veto of last resort, as it were. So there are a lot of veto points in the process, which are often blamed for the problems in failure to enact sufficient legislation. There are also critiques around representation or representativeness. And I think these can cash out at two levels, an individual level and a systemic level. So the individual level looks something like this. My member of Congress doesn't represent me. Maybe my member of Congress was picked by a far left or far right primary electorate, and I'm a more moderate guy, but kind of looking at the level of individual constituent and individual member, there's some slack in the representative relationship, that the representative isn't representing the constituents as they should be. There's also relatedly, but importantly distinct, a systemic critique here, which is Congress as a whole isn't representing the American people. So there's been good political science work, for example, showing that when the preferences of the middle class and the wealthy diverge, Congress is more likely to follow the preferences of the wealthy than those of the middle class. There's a great book called White Collar Government, noting that almost everyone in Congress has a college degree, and many folks have advanced degrees, whereas there are obviously well over 100 million Americans that don't have college degrees and advanced degrees. So there might be kind of a systemic representation problem in addition to individual level representation. There are other critiques as well. So we've got veto points, we've got representation. There are also critiques around norm violations, that there used to be norms that were followed, issues around deference between the parties, issues around what's called senatorial courtesy. And norms have been broken. I think a lot of norm violations got attention during the Trump years because Trump was sort of norm breaker extraordinaire. But I think norm violations in Congress can be traced back to the early mid-1990s. And there are a number of reasons for that. I'm happy to give my thoughts in the Q&A if people are interested. But I think through the late 90s, 2000s, and 2010s, we've seen a kind of slow and steady breakdown of norms in Congress. There are a ton of examples around the confirmation process, around the budget process, around any number of other things. Closely tied up with these norm violations is partisanship. To put it simply, Democrats are a little bit further to the left than they used to be, and Republicans are much further to the right than they used to be. So that's a dynamic called that's a dynamic called polarization. And there's also a dynamic called sorting, which is the idea that there are very few conservative Dems and liberal Republicans. We used to have kind of the paradigmatic, the New England Republican who was actually more liberal than lots of Dems, or the Southern Democrat who was actually more conservative relative to lots of Republicans, and that doesn't really exist anymore. We have a left and moving leftward Democratic Party and a right and moving hard rightward Republican Party. And tied up in that is lack of compromise, that the parties see politics in Washington as largely zero sum. Even if there is a bill that both parties could get behind, each is largely hesitant to give the other one a win or to do something that the other side may get credit for. And when that dynamic obtains, it obviously makes legislating much more difficult. Finally, in terms of kind of how to think about the substantive approach that I began with and the procedural approach that I just presented, we can also imagine a kind of blended approach. And this would say this, I'm very attracted to this. I'm working on a paper on this right now, that Congress is broken when procedural failures lead to substantively undesirable outcomes. So it's a blending of the substantive and procedural views. Let me just give a quick example, something called the Paycheck Fairness Act, which was proposed during the Obama administration. It would have made it much easier for women to raise pay discrimination claims against their employers, and it would have strengthened protections against retaliation. On a number of occasions, it received more than 50 votes in the Senate. It topped out at 58 votes in the Senate, which is a large, 58-42 is a very large majority. And if you count up those 58 votes, were from senators representing a significant majority of the country, that you had senators from New York and California and Illinois and a number of very large states. So it was 58 senators representing, I think, close to 2/3 of the country favored this bill, and the bill didn't pass because under the Senate filibuster, you need 60 votes to close debate. 58 is less than 60. The bill didn't pass. I think if you want to think about the failure of the Paycheck Fairness Act, one way to think about it is as a failure of procedure, namely the filibuster in this case, leading to a failure of substance of this bill that I think, obviously there were arguments against it, but that many believed was sensible, failed to pass. Great. Now I want to do a bit of a case study. I've mentioned the filibuster a number of times. I think these days in Congress, the filibuster is kind of the elephant in the room. You have Democrats with not a huge majority in the House, but with a significant majority, with certainly a governing majority. You have an ambitious Democrat in the White House. If legislation is going to fail, it will more likely than not fail in the Senate. The Senate, as you all know, is 50-50 with Vice President Harris as the tie-breaking vote. So it is the barest possible majority the Democrats have on the Senate side. So what are the relevant rules? How do we know what's going to pass the Senate and what's not? So there are three rules here that interlock and I think shed a lot of light on what things are going to look like in the months ahead. So the first and most important is Senate Rule 22. This is the rule that sets out a three-fifths threshold to close debate on legislation. So if there's a full Senate of 100 and you want to get a bill through, Senate Rule 22 says you need 60 senators. This is known as the cloture rule, sometimes colloquially as the filibuster rule. So that sets out the basic framework. We have an exception to that, though, and that's what's known as the budget reconciliation process. So this was created by the Budget Act of 1974 as an exception. And if you're legislating under reconciliation, I'll say more in a minute about what that means, you only need a simple majority, so 50 or 51 votes to close debate, rather than a 2/3 majority. So it's a much lower threshold. That raises the question, why not do everything through reconciliation? It's a lower threshold. It seems much more appealing if you want to legislate. And the answer is something called the Byrd Rule, which dates to the 1980s and was codified shortly after it was initially introduced. That's the late Senator Byrd smiling at us on our screen. And the Byrd Rule defines and limits the scope of the exception. The Byrd Rule tells us what can and can't be done through reconciliation. And the key point with the Byrd Rule is that in order for something to be done through reconciliation, it needs to be predominantly budgetary in its intent and or effects. There's a little bit of wiggle room there, but it needs to be predominantly budgetary. So let's think through reconciliation. The basics of the process is that Congress passes what's called reconciliation instructions, which is telling itself that it needs to that it is empowered to pass legislation that does X, Y, Z to taxes or spending or the budget. And then it can follow up on that. So for example, in order to pass tax cuts, the reconciliation instructions authorize Congress to add to the deficit within a certain amount of time, and then they were able to go ahead and pass tax cuts. As I mentioned, the Byrd Rule is the primary limitation on the reconciliation process. The other limitation is that much reconciliation legislation has a sunset. It's a little bit complicated as to how intrinsic that is, but it's quite common for reconciliation legislation to have a sunset. So when people talked about the Bush tax cuts expiring and needing to be extended or not, that was on account of them being passed through reconciliation. And I have on the screen here a few prominent examples of legislation in the last few decades done through reconciliation. So the welfare reform, Clinton's welfare reform bill, is probably the most prominent early example of social welfare legislation passed through reconciliation. All of the major tax cuts from both Presidents Bush and Trump were passed through reconciliation. And importantly, the sidecar bill the Affordable Care Act was. I just want to be clear on this because this is something that the Chief Justice got wrong in an opinion a couple of years ago. So I feel the need to preach the gospel on this one and clarify. The Affordable Care Act was not passed through reconciliation. The Affordable Care Act got 60 votes to break a filibuster in the winter of 2009, in 2009. The there was a sidecar bill after Senator Kennedy died in Massachusetts and Senator Scott Brown replaced him. Democrats had only 59, not 60 votes in the Senate. So there was this sidecar bill, this supplemental bill, the Affordable Care Act, that passed through reconciliation, but the ACA itself didn't. So the healthcare exchanges, the Medicaid expansion, all the parts of the ACA that you're probably familiar with passed through the ordinary process, not through reconciliation. So how does the Byrd Rule apply? I mentioned that the Byrd Rule requires that things going through reconciliation need to be predominantly budget related. Now, if you can tell me what is predominantly budget related, you can have a pretty good job on Capitol Hill, because it's extremely vague as to what meets that standard of predominantly budget related. And the Senate parliamentarian, who's kind of an internal judge, an internal referee within Congress, is the one who typically adjudicates Byrd Rule disputes. So let's say the majority party tries to enact provision X through reconciliation. The minority party says, I move to strike that on Byrd Rule grounds. It's not predominantly budgetary. The parliamentarian will adjudicate that challenge, will decide who's right. So let me give a couple of examples from ACA repeal efforts. So this was in the first year or two of the Trump administration. Republicans were trying to repeal the Affordable Care Act, and they tried to do that through reconciliation. The benefit of that for Republicans at the time was they only needed 50 votes, not 60. The downside, though, is that the Byrd Rule was going to limit what they could do. And let me just give two kind of somewhat tricky examples here. So one was Medicaid work requirements. So this is the idea of imposing work requirements in order for folks to be eligible for Medicaid. That seems budgetary, and that it's about who gets Medicaid, and the presence or absence of work requirements will affect how much the federal government spends to fund Medicaid programs in the states. That said, it also has kind of a regulatory flavor. It's about eligibility. So you could imagine going either way. Are Medicaid work requirements more regulatory or more budget related? The parliamentarian permitted them, which is to say the parliamentarian said that they were more budget related. Contrast that with defunding Planned Parenthood, which also seems sort of regulatory. It's about pursuing a vision of women's health policy, but also seems sort of budgetary. The word defunding is right there in the name. So is defunding Planned Parenthood permitted through the reconciliation process? And the parliamentarian said no, that of course it's about funding, but nobody was under any illusions that defunding Planned Parenthood was a deficit reduction measure. Everyone knew it was an attempt to enact real social policy. And the idea was that social policy needs to be pursued with 60 votes, not through the reconciliation process. So that's a case study of the Byrd Rule in the past. Let's take a minute to think about the Byrd Rule in the present. So what parts of the Biden agenda are permitted under reconciliation? So the good news for the administration on the COVID relief bill is that much of the relief bill is permitted under reconciliation. So anything that involves cutting checks. So funding for vaccine distribution, fine under reconciliation. Funding for individuals, those $1,400 checks, totally fine. Things like the Paycheck Protection Program, aid to businesses, fine. Aid to state and local government, near and dear to my heart as a state employee, also totally fine. So much of the COVID relief bill is permitted under reconciliation. So are a few measures that I think we're going to be seeing both in the COVID relief bill and more broadly that aren't directly related to economic recovery, most notably parts of the administration's climate policy. So if you want to subsidize green energy, that's something you can definitely do through the reconciliation process. So everything on this slide, I think the administration is on very safe ground proceeding through reconciliation. Other parts of the agenda are on shakier ground, and I just want to flag one of them, which is the minimum wage increase. So under a number of the proposed COVID relief packages, the minimum wage would be raised gradually, ultimately coming in a few years to a $15 an hour minimum wage. The question is this permissible under reconciliation? On its face, the answer would seem no. This isn't taxing and spending directly. This is rather regulatory. This is telling employers that they have to pay their employees above a certain wage. So I think there's a quite strong argument that a minimum wage increase is not permissible under reconciliation, at least as reconciliation has been understood in the past. That said, I think we're seeing seeds of this now in the press, Democrats are auditioning an argument that if you raise the minimum wage, that will put more money in people's pockets, which will lead to more spending. It will be stimulative. It will increase tax revenue, both directly and indirectly, and thus have an impact on the federal budget, and thus be permissible under reconciliation. This is, I think, an aggressive interpretation. I don't think it's crazy. It might well work, but this is, I think, an aggressive interpretation, whereas the content on the last slide, COVID relief and green energy subsidies, I think the Democrats are on much safer ground. The other question here, the kind of elephant in the room looming over all of this and looming over the reconciliation process, is will Democrats end the filibuster? So the filibuster has been chipped away at over the past decade, and there have been two notable chippings away. The first by Democrats in 2013, the second by Republicans in 2017. So the chipping away by Democrats in 2013 was when Democrats felt stonewalled on a number of their nominees, most notably judicial nominees, including a few to the DC Circuit, nomination to head the Consumer Financial Protection Bureau. So both judicial and executive branch nominees were being blocked by Senate Republicans. And the Democrats, at that point, they had more than 50, but less than 60 votes. They would lose their majority in 2014. But in 2013, they eliminated the filibuster for executive branch and lower court nominees. That left it in place only for one class of nominees, namely Supreme Court nominees. And the Republicans in 2017 ended it for Supreme Court nominees. This is when they had more than 50, but less than 60 votes. Democrats were filibustering then Judge Gorsuch. Republicans responded by ending the filibuster. So we've seen this chipping away, and the question is, will it be chipped away at further or eliminated altogether? A quick note, and I don't want to get too into the weeds on this, is the mechanics of ending the filibuster, either in whole or in part, is through kind of a common law process within Congress. So the idea here is that there would be a point of order on the floor, there would be a ruling, and then that ruling would be appealed by a party that had 50 or 51 votes to change the rules. So it wouldn't be through passage of a new resolution or a passage of a new statute. Rather, it would be through kind of parliamentary practice and this creative process of appealing a ruling from the floor, which I'm happy to talk more about if people are curious about the mechanics. So will this happen, and what are the political dynamics here? I think it is unlikely, but not impossible, that it will happen. It would take all 50 Democratic senators in agreement to end the filibuster, and two of them, Joe Manchin of West Virginia and Kristen Sinema of Arizona, seen as the two most moderate members of the Democratic coalition, have gone on the record publicly saying that they will not end the filibuster. Senator Manchin has been especially adamant on this point. Why not? So there are a couple of things. The first of which is, I think, a general risk aversion. I think parties know that they may be in the majority today, but they'll be in the minority later. And one of the characteristic features of the modern Congress is extreme instability that we have seen much more frequently now than in kind of the mid-20th century. We see very frequent changes in party control. Given those very frequent changes in party control, some are hesitant. Okay, we can enact our agenda now, but in 2 or 4 or 6 years, we're going to be giving the other party a blank check. So that's the risk aversion point. The second point is a point about hesitation from moderates. That if you're Joe Manchin, you might be worried that ending the filibuster is going to open up the floodgates of liberal legislation that you're not comfortable with. It might force you into taking some really hard votes, some of which were the kind of lose-lose votes for you, where either you side with your party and anger people back home in West Virginia, or you side with your constituents but anger your party leaders. And it might be easier for a moderate to just avoid those choices by keeping the filibuster in place. A third dynamic, which I call on the slide asymmetric agendas, is I think there is a greater recognition that Democrats are more dependent on legislation for their agendas than Republicans. I think one of the really striking features of the Trump administration, for all the tumult and ups and downs and news stories, is there was very little legislation and very little by way of legislative efforts even. We had the tax cuts, by far the most important legislative achievement. We had the First Step Act, which was a bipartisan criminal justice bill. We had the failed attempts to repeal the Affordable Care Act. And that's more or less it. It was kind of a highly unambitious presidency from a legislative perspective, even on issues that President Trump really cared about. You could have imagined him introducing an immigration bill to really crack down, but instead he made immigration policy through the executive branch. There wasn't a lot of legislation going on. Contrast that with Democrats. Democrats are a party of high legislative ambition, and I think ever increasing legislative ambition. That Elizabeth Warren famously talked about the plans that she had. She had a plan for everything. I think the Biden administration has very much inherited that mentality, that there is a plan, one that would ideally include legislation for more or less every issue that Democrats care about. So I think when Democrats have these very ambitious agendas and Republicans have much less ambitious agendas, we see a kind of asymmetry with respect to the filibuster. If you have a more ambitious agenda, the filibuster is more of an impediment. If you have a less ambitious agenda, especially an agenda that includes tax cuts, which you can do in spite of the filibuster, maybe you're more okay leaving the filibuster in place. A final point is interest group motivations within political coalitions. So when I think about folks in the Democratic coalition today, when I talk to climate folks, they're ready to end the filibuster now. They have big plans. They want a climate bill. The filibuster stands in the way. Let's go for it. When I talk to folks concerned about reproductive rights, they're a lot more nervous. They don't necessarily have kind of a grand short-term legislative ambition, but they're really worried that if and when Republicans take back power, we would see restrictions on abortion at the federal level in addition to at the state level. So using kind of using environmental groups and reproductive rights groups as kind of foils, even within the Democratic coalition, there are differences of opinion on ending the filibuster, because I think there's a recognition it would have disparate effects on different types of issues. Finally, I'll end by asking about congressional reform. So if you think Congress is broken, what are the levers you might pull? How might Congress work differently or work better? And there are two big buckets of levers, one within Congress and one outside of Congress. So the bucket within Congress includes most notably filibuster reform, which I've already been talking about, but a few others as well that I'll just mention briefly. One is the power of party leaders. You might think that party leaders are too strong, that the problem is party leaders whip their members in line, and if you had more members from purple states and districts voting their constituency, we'd be better off. On another view, party leaders are too weak, and party leaders are actually the only people preventing the kind of hard flanks from taking over the chamber. So I think there's a lot of talk on Capitol Hill nowadays around the power of party leaders. We have relatively strong party leaders, but they're constantly facing challenges to their leadership, both Democrats and Republicans in both the House and the Senate. And I do not envy Chuck Schumer or Mitch McConnell or Nancy Pelosi or Kevin McCarthy. I think the jobs of holding these coalitions together are exceptionally difficult. Another issue that's gotten a decent amount of play in Congress circles is issues around legislative capacity. There's a sense that Congress could work better if it had more staff, if it had more experienced staff. A lot of Hill staffers are my age or younger, whereas people with more experience go off to law firms or lobbying firms or elsewhere where they can get paid more. And there's a question around how can we build up Congress's legislative capacity internally? And Congress already has some resources here. The Congressional Budget Office is very good. The Congressional Research Service is very good. But what else can Congress do, especially at the level of committee staffing and member staffing, to build up their capacity? And then finally, there's a whole suite of other rules, some of which, like earmark rules, you can imagine tweaking in order to try to better facilitate deal making. Other rules like revolving door rules might be changed in kind of the service of an anti-corruption agenda. There's a lot of potential levers you can pull within Congress. More familiar, perhaps, are levers you can pull outside of Congress. So there's certainly electoral rules. Members of Congress have electoral connections to their constituents. Much of what they do is explained by their constituents. And to the extent to which you can change things like party primary rules, things like gerrymandering and the drawing of districts, electoral rules might change what goes on. Changes to electoral rules might change what goes on in Congress itself. We also have campaign finance rules. So we could imagine dramatic campaign finance overhaul, which has been proposed and would be unlikely to survive the current Supreme Court. There are also much more modest reforms that you could imagine. Most notably, a bill that I really like that was introduced a couple of years ago on a bipartisan basis would prohibit members of Congress from soliciting donations individually. So if they want to keynote a fundraiser, that's great. If people want to give money to them, that's great. But the whole 6 hours a day dialing for dollars rather than doing the people's business would be prohibited. So you can imagine even minor tweaks to campaign finance rules might have big effects on what happens on Capitol Hill. So I'll end there and open it up for questions. These are really exciting times to be thinking about Congress. I think we are going to see a lot of both excitement and also potentially frustration in the months and years ahead. So I'm eager to continue watching Congress and to continue the conversation with all of you. So let me pull up a couple of questions that I got in advance, and then I see we have 9 questions that have come through. And if other folks want to jump in, I am happy to hear from you all on those. Yeah, these are all terrific questions, and we have, I know, 19 minutes, so I'll try to be brief in my answers. So one of you asked whether there are long-term solutions to representational inequality. This is the idea that Wyoming has 1/60th the population of California, but has the same number of senators. And is there anything to be done about that? And in particular, the questioner asked about voting power, that could you imagine giving more voting power to California's senators? Formally speaking, the answer is no. The Constitution says each senator shall have 1 vote. That said, most observers, including myself, interpret that to mean 1 vote on final passage. And you could imagine clever quorum rules or cloture rules or kind of other votes pre-final passage where you gave California senators greater power. And that's something I'm actually working on now. So it's a great question, and I would say stay tuned. Another question is around primaries, and in particular, should we reform primaries? Should we have ranked choice voting? To me, answering that question depends on what is the goal. So if your goal is to better represent the democratic will, I would say 100%. If you want legislators to better represent their districts, ranked choice voting is great. And I'll give an example from the congressional district where I spent most of my life, the Massachusetts 4th. There was just a congressional race. There were about a dozen candidates, most extremely liberal. The most moderate candidate, who I think was to the right of the district median, won because the more liberal candidates split their vote. And I think in that case, ranked choice voting would have given a more liberal candidate who would have been better represented the district. Interestingly, the Utah Republican Party is also behind ranked choice voting because they see a kind of mirror image dynamic in Utah from what you have in Massachusetts, where in Utah, there are concerns that, again, the conservatives are splitting votes and moderates are winning. So ranked choice voting in terms of better representing the will of the district would be a positive thing. It might lead to more liberal members in some districts, more moderate members in other districts, more conservative members in yet other districts. As to what it would do to the ideological composition of Congress as a whole is much harder to say. If the goal is to reduce polarization, I am not terribly optimistic about small changes like ranked choice voting. I think reducing polarization would take much larger changes, either to campaign finance or to the structure of party primaries in the first instance. Great, a few other questions. So one of you asked the basis of the power of the Senate Majority Leader to block legislation from even moving to a vote. So this, I imagine, may have been inspired by the Merrick Garland affair, where Mitch McConnell just declined to put the nomination up for a vote on the Senate floor. And indeed, the Republican-controlled Senate Judiciary Committee declined to hold a hearing. Under current norms, and this is not by and large written into the rules, majority party leaders have extremely strong control over what goes on the floor. They are, for obvious reasons, hesitant to relinquish that control, but you could imagine various mechanisms to reduce their control. There's something called a discharge petition, which allows a majority of Congress to discharge a bill out of committee, even over the committee's objection. And you could imagine something analogous on the floor, kind of some mechanism for allowing a floor vote even over the objection of the majority party. But for now, at least, the majority party has an enormous amount of power. Let me see here. One of you asked whether members of Congress are bound by resolutions taken by their local constituents. It's a really interesting question, and actually the founding fathers thought about this and debated this, but decided against it. So this is something that was one of the hottest issues in the 1780s and 90s. The right to instruct representatives was nearly included in the First Amendment, but it wasn't included, and we have since then thought of legislators as free agents. And I think constituents could try to instruct their legislators, but I don't think it would necessarily be effective. One of you asked about the fact that members of Congress are spending more and more time in DC, are spending less and less time in DC, and thus not getting to know each other. And this is certainly true. I mean, members of Congress used to, with much greater frequency than today, move their families to DC, enroll their kids in DC or suburban DC schools, become part of the community, whereas now many members of Congress are flying back home every single weekend. Do I think that contributes to polarization? Yes. I think the effects of that might be somewhat overstated. I think the issue here fundamentally isn't that Democrats and Republicans need to get a beer together. I think it's that Democrats and Republicans face very different electoral incentives and very different primary electorates and very different funding bases. And I think those fundamentals matter more. A number of you have asked about term limits. I am a term limit skeptic. I'll say firstly, on legal grounds, it is not clear that term limits would be constitutional. There was a case from the 1990s striking down term limits when a state legislature and a state government tried to impose term limits on its members of Congress. The analysis might be different for federally imposed term limits, but I think I would bet 50-50 or greater that even federally imposed term limits would be struck down. So I think constitutionally there's a big problem. I also think expertise matters. I mean, there's been good comparative politics studies of state legislatures that do and don't have term limits. And the ones that don't tend to work better. You get members who spend a long time in the legislature, who develop relationships, who develop expertise, who aren't constantly looking for the next job, either another elected office or the private sector. So I actually think, if anything, the problem is members of Congress aren't spending enough time building up expertise. I think having more frequent turnover might create negative effects that aren't fully recognized. Other questions here. One of you asked, are there limits on the ability of the feds to impact how states conduct elections? The answer is there are limits, but the authority of the feds is extremely broad. Nick Stephanopoulos, who's a leading election law scholar, has a good paper on this recently, arguing that if Congress wanted to pass a law providing automatic voter registration, mandating mail-in ballot options, kind of a whole suite of pro-voting reforms, it could do that legally, at least under current law, and that the challenge is much more a political challenge than a legal challenge in getting that done. One of you asked about misinformation and disinformation. How much is misinformation / disinformation factor into the idea that Congress is not working? So I will say a couple things. I think the question is getting at misinformation that members of Congress might themselves be consuming, or misinformation that their constituents are consuming. But I will say that Congress gets a bad rap, and when push comes to shove, actually it does okay on some things, especially in emergencies. So 11 years ago, in the midst of the financial crisis, Congress passed TARP, the Troubled Asset Relief Program, I guess 12 or 13 years ago now. And then even in the midst of, Nancy Pelosi and Donald Trump came to agreement on a COVID relief bill last spring. So kind of when push comes to shove, Congress does get things done if there's a sense of a short-term emergency. They're really bad at addressing long-term problems, which are many of the problems that I talked about in the talk. In terms of misinformation, this, I imagine the concern is around social media and lies being told on Facebook and kind of QAnon. I think all of that is an enormous problem. I think it will only get greater with time. And I think the decision by the Republican caucus not to remove Marjorie Taylor Greene from her committee assignments was a really foreboding moment. I think it is possible that the Republican Party, without giving up any of its conservatism, it could have remained as the party of low taxes and free markets and traditional values and a largely white Christian base. It could have retained all of that while denouncing misinformation. And it didn't do that, at least not on Marjorie Taylor Greene. So I'm extremely worried about misinformation going forward, though I sadly don't have a great answer there. One of you asks about delegations, the executive branch, and how this affects Congress's role and Congress's ability to function. And the idea here is, I think, from the questioner, is that Congress has abrogated its responsibilities. So when it passes broad statutes delegating a lot of power to deal with emergencies to the executive branch, it's able to say, not our problem, let the executive branch, let him handle it, we don't have to jump in here. I think there's some truth to that. I'll note that Congress tried to retain more power and actually has been thwarted by the courts. So let me give an example here. So the National Emergencies Act was passed decades ago with a legislative veto. So the idea under the National Emergencies Act as originally passed is the president could declare a national emergency, but then Congress could after the fact say, no, that's not a bona fide or legitimate national emergency. So Congress had a kind of ex post veto on national emergency declarations. That was struck down by the court, not in that statute, but in the Chadha case, which was a similar legislative veto provision in the immigration context. And there were over 100 legislative vetoes like the one I described in the national emergencies context, struck down across the US Code. And what does that mean? Now we have this National Emergencies Act, which is an extremely broad delegation, which is potentially subject to abuse, as we saw, for example, with the attempt to divert funds for the border wall. And yet Congress, which had intended to give itself a tool to deal with that, doesn't really have a tool to deal with that, short of modifying the statute, which it's not in a position to do. So I think delegations are maybe a little bit the problem, but I think it's delegations kind of in conjunction with judicial doctrine, which create a bigger problem. A couple of other questions. One of you asked about the authority of Congress to increase the number of federal judges. The answer is that Congress has plenary authority to do that. At the district court level, at the circuit court level, at the Supreme Court level, the only thing potentially stopping Congress is political will, but there are no legal or constitutional constraints to increasing the size of the federal judiciary. And in fact, it's been done a number of times. I mean, the Supreme Court was once 7 justices, in the mid-19th century was raised to 9. And there have been periodic, often bipartisan attempts to grow the lower federal courts. The country has gotten bigger. There are a lot more Americans than there used to be. There have been calls for more district and circuit judges to deal with that. Can the Senate vote to overrule the parliamentarian on a Byrd Act decision? Yes, absolutely. So it is conceivable that we would see a Byrd rule decision going against the Democrats and then an appeal to the floor where the Democrats thought that they might be able to overrule that decision. And that's happened a couple dozen times. It's not terribly frequent. In order to overrule that decision, though, they would need Manchin and Sinema. So I think they would only be able to do that if they had a perfectly unified caucus. And I think when Joe Manchin says, I'm not going to eliminate the filibuster or chip away at it, I think the or chip away at it is really a reference is really a reference to gamesmanship like that, to appeals to weaken the filibuster. I'll end with a question around, is the blended failure analysis for the House the same as the Senate? One of you correctly notes that most of the discussion relates to failure in the Senate. I think that's right. I think the combination of unequal representation coupled with the filibuster makes the Senate a much bigger problem, both from a small d democratic perspective of representing the people, and for a big D democratic perspective of enacting the Democratic Party's agenda. So I think it is unsurprising with Democrats in power that a lot of dysfunction focuses on the Senate. There are many critiques of the House as well. We didn't talk about gerrymandering today, which is a House problem, not a Senate problem. I think there are a number of other problems that are specific to the House. I do not want to give the impression that everything is hunky-dory on the House side, but I think kind of the deepest dysfunctions largely lie with the Senate. And I am sorry to not be ending on a more optimistic note, but I've really enjoyed these. Were fantastic questions, and I think I'll throw it back to Yuri to wrap us up.
Great. Thank you very much, Professor Gould, for that very enlightening talk. And I want to thank all of you who were able to join this call for participating and asking these great questions. And again, I want to encourage all of you to check out the upcoming events that we have as part of our Alumni Association. So thank you again, and take care, be well, stay healthy.
Thanks, everyone. Be well.